We are Sawyer Fielding, Chartered Surveyors who specialise in helping homeowners affected by the threat of compulsory purchase. This video is one of a number of guides to explain to our clients their entitlements, the processes involved, and how we can help. This video is to explain what you can expect if you're unfortunate enough to have to go all the way through the process of a typical Regeneration compulsory purchase order. For simplicity, we'll look at it in 10 steps, but do bear in mind that this is just a typical guide. Some of the process can vary. If you're affected by the threat of compulsory purchase, please do not be unduly worried about the process that's involved. At least not unless you get to the very final stages, which is extremely rare. Most sales on compulsory purchase terms are done either without a formal process even beginning or at a very early stage of it. Step 1. The consultation. This is when you'll start to be invited to events where the council explain what could happen. There may be a series of pledges on how you'll be treated, possibly displays showing what new homes could look like, and homeowner booklets are produced to explain what to expect. It may be that negotiations for the sale start, but that can begin at a later phase. Step 2. If the council are partnering with a developer, possibly a housing association too, in what is known as a joint venture, they'll look to set the rules on who does what and who pays for what. They may then draw up a master plan and apply for planning permission for the new development. Step 3. The resolution. Councils work like mini-governments in some ways. They have a cabinet formed of a number of elected councillors who will make the important decisions, in this case to prepare a compulsory purchase order, providing what is known as a resolution. Step 4. The land referencing. This is a questionnaire being sent to everyone who is affected, called land referencing, often done by an external company. This will ask you things like who owns the property, who lives there, and who the mortgage is with. This information is used to simply ensure that when the CPO is made, everyone who is entitled to be notified is notified. It's important, therefore, that you do answer the questions. If you don't know any of the answers, like the term of your lease, we can find out for you. Step 5. The order is made. This is when a lot of people get worried. They needn't though. The order is merely the council's request to government for permission to take ownership of your property without your consent. They're still a long way off actually having that permission. You can still negotiate. The order contains a number of documents which might appear rather officious. That's simply because of a legal requirement though. Objections can be made to the order, but on limited grounds and within a short window of time. Step 6. The public inquiry. If there are any objections made to the order which are not withdrawn, an inquiry takes place. This is similar to a courtroom, but normally held somewhere relatively local, such as a town hall. This is where the merits of the CPO are considered by a government-appointed inspector, who hears evidence from those in favour of and against the order. There are strict rules on how evidence can be heard, and only that which is directly related to a set of legal principles can be considered. The inspector will then make a recommendation to government on whether or not to confirm the order, that is to grant the council the compulsory purchase powers. Sometimes the inspector is authorised to make the decision themselves as well. Step 7. If the order is rejected, it's back to square one. However, in over 95% of cases, the order is confirmed, granting the council powers. This can now get a bit scarier as all of a sudden, after serving a number of formal notices, they have the power to take ownership of your home. You're still able to negotiate by a sale of agreement, but negotiations when one side can take something by force are always more difficult. Step 8. The General Vesting Declaration. This is the formal name of a statutory notice, which sets a date at which the council own your home. You can sell at any time until this date. After that is compensation you receive instead. This is even scarier as they can take ownership before they've paid you a penny. That's why it's called compulsory purchase. It can take a little while until you receive any compensation, albeit we can serve a protective notice to request something called an advance payment. Step 9. The bailiffs. This is a position nobody wants to get to. You've probably seen bailiffs on TV programs where they change the locks. It's the same thing. You'd be given notice beforehand, but it's still a horrible experience to be forced out. especially as, unlike on those TV programs where it's normally because someone hasn't paid a debt, you've done nothing wrong. There is still a good chance that you haven't actually received any money yet, so if possible, things really shouldn't be allowed to get to this stage. Step 10. The final settlement. Well, firstly, let's hope that you've long since sold by agreement before you've got anywhere near this point. If you haven't though, the final settlement for how much you are being paid is done one of two ways. Either it's been negotiated, or it's been determined by the Land Chamber. For CPO matters, the Land Chamber only hears matters in the upper tribunal. That means getting justice can be extremely expensive and time-consuming. Cases can run into the tens of thousands of pounds, and sometimes much more, and it's rare that you'd get any of that back. It's also important to remember that if the worst happens and you lose your property to the CPO, whilst you can keep negotiating forever, after 6 years you lose the right to apply to the tribunal. That means after 6 years, the claim can be assessed as nil and there'll be little you can do about it. This 10-stage process is only indicative. It can vary from one scheme to another. If we're representing you from early on in the process, you really should not get anywhere near the worrying final stages. However, if negotiations are protracted, we have the experience to see it right the way through to make sure you get a fair and reasonable deal. Hopefully that has proven helpful. Please do check out our other videos at www.sawyerfielding.co.uk/videos. If you would like to talk to us in person, we're a friendly bunch, so please do get in touch. We can be reached on 020 3011 5300, or you can email us at info@sawyerfielding.co.uk.